Hello everyone, welcome back. This is SC Coleman, author, and in this video we're going to be talking about the real world physical manifestation of Skynet. Of course, as most people know, Skynet is a quote fictional entity, character creation, idea or concept found in the Terminator movie series. And of course, really the only one of those that makes any difference or matters is the first one, and all the other ones are just garbage attempting to obfuscate the first. So this first thing we're going to look at is Memorandum of Agreement between the Department of Homeland Security and Department of Defense regarding cyber security. Purpose of the agreement is set forth terms by which DoD will provide personnel, equipment, and facilities in order to increase interdepartmental collaboration and strategic planning for the nation's cybersecurity, mutual support for cybersecurity capabilities development, and synchronization of current operational cybersecurity mission activities. This is, of course, part of the usual thing that I've been talking about in these videos, is that a foreign United Nations attorney weaponized structure organization, if you will, is attempting to transition all U.S.-based, specifically military assets, to their control, if not absolute global domination, through this thing they're calling global law enforcement, which will mostly be automated through the Amazon Web Services. Identify and assign in coordination with the Department of Defense a DHS Director of Cybersecurity Coordination who will be in the national protection and, oh, by the way, this is apparently cleared for open publication on October 13th, 2010. Yeah, right. Programs Directorate, and will be located at the National Security Agency, NSA, but will not be in the NSA chain of command. Isn't that interesting? Identify qualified DHS personnel to perform DHS functions under the role, supervision, and direction of DHS officials as follows. Assign DHS personnel to work at NSA as part of Joint Coordination Element, JCE. Assign personnel to work at the NSA Directorate of Acquisition for collaborative acquisition. Assign representatives from the Office of the General Counsel. Now here's your kicker. In all of these, they have some kind of special provision to involve the offices of the General Counsel, quote unquote. Assign representatives from the Office of the General Counsel, Privacy Office, and Office of Civil Rights and Civil Liberties to support the DHS Director of Cybersecurity Coordination at NSA and coordinate with the DoD counterparts identified in paragraph B2D. This, just like all the other documents, was certainly written by an attorney or attorneys. Ensure that DHS personnel have current security clearances, TSSCI, upon assignment to NSA. Now that is something that should really trouble people, because among all of the nasty things that NSA has been doing, DHS plans to do much worse, if not already doing much worse. Provide appropriate access, administrative support, and space for an NSA cryptologic services group at DHS and integration into DHS's cybersecurity operations activities. Department of Defense. Direct the Director of NSA DERNZA and Commander U.S. Cybercom to undertake the collaborative activities and provide cybersecurity support envisioned in this agreement and subsequent implementing agreements. Receive and coordinate DHS requests for cybersecurity support and consider DHS requirements as appropriate and consistent with applicable law and NSA mission requirements and authorities in operational planning and mission coordination. As we go through these documents, it's going to get a lot worse. Provide appropriate access, facilities, and administrative support, including necessary equipment and connectivity to support the Director of Cybersecurity Coordination and DHS personnel assigned or detailed to the three entities listed below. NSA will provide all necessary NSA equipment and connectivity to permit DHS personnel with the capability to carry out their roles and responsibilities. Joint DoD-DHS develop jointly appropriate agreements, including necessary funding mechanisms to implement the objectives and responsibilities of this agreement pursuant to applicable authority. So, of course, it's all this other memorandums of nonsense and garbage, and of course they're doing this all under the fraudulent pretext of the sanctity of law enforcement, and that just because it's, quote, law enforcement, it means they can do whatever the hell they want, right? Deputy oversight, by the way, Deputy Secretary of Homeland Security, whatever that is, and the Deputy Secretary of Defense will conduct monthly oversight meetings. DHS Deputy Undersecretary, National Protection and Programs Directorate, NPPD, and Principal Deputy Undersecretary of Defense for Policy, and the Director of NSA, Commander, U.S. Cybercom. Points of contact: Philip Ratinger, it's probably a false name, Deputy Undersecretary, National Protection and Programs Directorate, and James N. Miller, also probably a false name, Principal Deputy Undersecretary of Defense for Policy. And these were allegedly signed in 2010, however, by Robert Gates, Secretary of Defense, and Janet Napolitano, Secretary of Homeland Security. Now, they're allegedly signed in 2010, listing Robert Gates as Secretary of Defense. That's interesting. And to Janet Napolitano as Secretary of Homeland Security. Now, as far as I'm aware, I've seen more recent filings listing that same name, so that's interesting. And these appear to be photocopied, these signatures right here. They do not look to be real. Of course, none of this stuff is really real, is it? And the people carrying this stuff out, ignorantly or otherwise, are engaged in active operations of treason and enemy warfare against the nation and country, being the people and the land. June 13th, 2017, action. Memorandum for distribution from the alleged Undersecretary for Management. They really love their undersecretaries and assistant deputies and all this other nonsense where they give themselves lofty powers by being just assistants and nonsense like that. We got the Chief Privacy Officer, allegedly. Review of safeguarding policies and procedures for personnel-related data. Transport Security Administration to safeguard PII of our personnel. They like that word, they use that there. Our. Safeguard PII of our personnel. Personnel-related data is a subset of PII and includes any PII about the Department of Homeland Security. Now, why would they want specifically, above all else, to control that? Oh, you can only imagine, right? Such as human capital operations, security operations, and financial operations. Well, financial operations is money laundering, obviously, and fraud. Security operations is, of course, all the nasty stuff that they're going to do, and human capital operations obviously has to do with the individuals carrying them out, and any of those things being targeted is, of course, going to damage their operational capabilities, which, above all else, they want to protect because they are an occupying enemy force. We are directing all component and directorates to examine the entire breadth of the organization, even down to the smallest office, so that DHS is in a position to better understand and identify possible issues before the next incident occurs. So obviously they came up with some fake incident, as they always do, as a pretext and excuse to go through the organization and weed out any possible quote-unquote risks, those either being whistleblowers or people who will not quote-unquote comply with directives, and eliminate them and ensure that the only people left are their cronies and up to an extent loyal minions. And then they flush the whole system with all of these woke moronic lunatics that come out of the so-called education system, so they can of course get away with what they know to be treason without any organizational internal problems anyway. So this next document lists no name on it, but it does list the AGIS Deputy Assistant Secretary, Bureau of Administration, Global Information Services. It's an interesting name, weird. From May 2024, name of system is the PRM RPC AWS GovCloud instance. Bureau is the Population, Refugees, and Migration. iMatrix Asset ID numbers 308235. Child Systems and iMatrix Asset ID number, if applicable, is listed as NA. So I expect that's going to be a whole separate one involving children, which is, of course, is really important, big deal, because of the large, wide-scale operations of child harvesting and trafficking of things like adrenochrome and other biologicals that are harvested from the bodies of children, and those children are then, of course, disposed of with regular garbage in special EPA or Environmental Protection Agency protected dumping sites. The Refugee Processing Center Amazon Web Services RPC AWS GovCloud system provides general system support to the Refugee Processing Center and additional support to the START application. Now, the first thing I want to preface this with is that when we get further into this specific document, we'll find out that this refugee word here is just a mind-bogglingly used pretext for extensive, massive spying and espionage on U.S. citizens. It's amazing that you can have these foreign United Nations attorneys come in, seize control of the entire immigration system, of course, to protect themselves, and then leverage the pretext of immigration as an excuse to spy on every single U.S. citizen without any apparent form of pushback or anything. They just can do it. It's pretty amazing. Serves as a data sharing vehicle with several of the key partners named below. Key users to the RPC AWS GovCloud include users at the RPC resettlement support centers, United States government partners, and non-governmental organization partners. And like I said before, this whole immigrant refugee stuff is just a facade. It's a cover story. AWS GovCloud is an isolated AWS data center region designed to host sensitive data and regulated workloads in the cloud and meet U.S. government compliance requirements. Support a global case management system. That global case management system is a big deal, as we will see in future documents. RPC AWS uses and maintains PI for all refugee applicants, non-U.S. persons who. RPC AWS also contains PII about anchor relatives and or U.S. ties already located in the U.S. which could potentially support refugees once arrived. So first of all, they are anchors, so-called, who could potentially support refugees once arrived. That is every U.S. citizen, and this idea of U.S. ties can be as minimal as you had developed a passing acquaintance. Right? This idea of U.S. ties can really be broadly applied, and essentially every single person in the United States has had some kind of contact with foreigners. So therefore, they are using and leveraging the cover and pretext of immigration to essentially gotta catch them all plan on every U.S. citizen in this refugee database function system. It completely throws out the window any possible explanation that it's being done for, that it's being applied to the due process requirement in the Constitution for a search, specifically. Well, what is the phrase in the Constitution? To be secure in one's persons, papers, and effects. Or, well, one's houses, persons, papers, and effects. Obviously, we are in no way at all, in any shape possibly at all whatsoever, secure in any of those categories. They can, without limitation, collect and disseminate information to any level, make any search they desire, with no due process, as far as the Constitution's due process is concerned, at will, through a private corporation, meaning Amazon. It's quite staggering. Results of DHS USCIS interviews on applicants. AWS may contain the following information about anchor relatives. That's your word there, anchor. It does not have to be a family member. They're using the word relatives, but like I said before up here, it says and or U.S. ties already located in the U.S. Anchor relatives of the refugee applicant, parents, spouses, siblings, and children who are U.S. persons and or U.S. ties. Like I said, and or U.S. ties. You're going to have all the usual biographical information you would expect. For the purpose of this collection, PIA collected, used, maintained, or disseminated on U.S. persons only will be discussed after this section. The majority of this paperwork, even though it starts out talking about so-called refugees and foreigners and immigrants, the majority of the paperwork of which is, let me see, it's one, two, they don't have page numbers on this, which was already very unprofessional, but we got 1, 2, 3, 4, 5, 6, 7, 8 pages talking about U.S. persons of a 9-page document. Isn't that amazing? The PI listed above for anchor relatives comes directly from START and is replicated in the system through daily batch transfers via START to AWS via an API accessible programming interface call. If yes, please indicate relative system of records notice, SORN below, SORN name and number. State 59 is what's referenced here. What categories of individuals originally provide the PII and the system? Members of the public, U.S. persons, which includes U.S. citizens or LPRs. And of course, that's going to be voluntarily hidden on various documents and paperwork that people sign throughout their lives. The PII comes directly from START and is assumed accurate. So obviously they have that separation stage there so that people wouldn't be able to actually track down the originator. The PII in the system comes directly from START, and no further steps are taken to ensure that PII remains current. Notice is not provided to the record subject. Since the PII comes directly from START, given this, it is START's responsibility to provide notice to the record subject at the point of collection. Whether they, decide to or not, I guess it doesn't really matter because it's their responsibility, not ours, and they are, of course, a shell entity for which we launder all of this information through so that we can do this nasty activity and no one's the wiser. Are opportunities available for record subjects to decline to provide the PII? No. There are not opportunities available for record subjects, the U.S. citizens, to decline to provide the PII. The PII in the system comes directly from START. It is START's responsibility to give opportunities for record subjects to provide consent. And yet it is not done. Hence the use of the word no. What procedures allow record subjects to gain access to the information? Anchor relatives cannot access the system directly. And again, it mentions State 59. To what entities outside of the owning office? It's funny, it's the owning office, right? They collect this information on you and they own it because they collected it. That's just insane. Will the PII be transmitted? Office of the Legal Advisor, of course. For each of the entities in 7A, list the PII Form 3B that will be transmitted. U.S. person's full name, business address, business email, and phone number. Internal within the department, RPC AWS information is shared by encrypted transmission via ServiceNow ITSM tool. Here's another layer that gets moved through. Permitted by internal Department of State policy for the handling and transmission of sensitive but unclassified information. And I expect, of course, they also handle quote-unquote classified, even though classification is simply a marking that anyone can put on any document at all. Classification is in itself not inherently something sacred, even though they make it out to be. Information is transmitted through encrypted emails, but it is only shared on a case-by-case basis with those who need to know. The requests for information go directly to the system administrator for fulfillment. The transfer data is both encrypted and in read-only format to ensure the integrity of the report. Or when the information is transmitted through encrypted requests in ITSM, it is only shared on a case-by-case basis with those who need to know. Further, the owning office of IRM has a memorandum of understanding agreement in place within state to enforce the required management and technical security controls, such as activity monitoring and malware detection, to meet cloud security concerns of both parties. This is definitely treason to the highest order, as are pretty much all these documents. So I guess that's sort of beating a dead horse. RPC AWS implements role-based access controls to enforce the principles of least privilege, separation of duties, and need to know. Further, audit trails deter users from inappropriate accessing or misusing the information. A subset activities and events by RPC AWS authorized users are logged and audited periodically for suspicious activities. There is a planned implementation of near real-time monitoring of both RPC AWS application using the Splunk System Information and Event Monitoring SIEM tool. Splunk is a log shipping and log aggregating tool that allows for the collection of system information such as login metadata and allows for the creation of dashboards to expose security information, querying of logs for particular metadata, and the ability to create alerts based on particular queries that trigger on relevant events. Where is the information housed? FedRAMP Certified Cloud. The data is stored in a FedRAMP approved AWS Glove Cloud East. And this also lists OpenNet users. Now, OpenNet here is one word with O and N capitalized. So O and open capitalized and net capitalized. Here, you might be able to see that. That's probably the name of an actual software, and they're probably not referring to the OpenNet or what others might refer to as the ClearNet, meaning the regular online open access to all type of deal. And this, again, lists OpenNet users. So from that document, we're going to go on to Greenberg-Traurig. Now, from what document we just read, this document is clearly going to be sort of managing perspectives, if you will. The Dutch Ministry of Justice and Security, NCSC, Greenberg-Traurig, LLP, Harold Jongen, Gretchen Ramos, and Wouter van Wengen, or as we would say, Wouter van Wengen. It's it's a Dutch name, so probably anyway. November 17th, 2022, number of Cloud Act requests. The risk of disclosure of EU residents' personal data or other data under the Cloud Act seems to be very low. Transparency reports of the three of the largest U.S. cloud service providers, Microsoft, Amazon, and IBM, who store personal data outside the U.S., which is the remit of the Cloud Act, contain the following relevant information. Since July 2020, Amazon has consistently stated that they have not disclosed any enterprise or government content data stored outside the U.S. to U.S. law enforcement. Well, of course they wouldn't, because that information is stored within the United States, so of course they wouldn't have to transfer it from outside the United States. They would just transfer it right within the system, and not to mention the whole Amazon Web Services is all over the place, so it's one of those word twisting things where they're obviously doing it, but they can declare that they're not doing it according to these particular narrow parameters. Some argue that using non-U.S. EU providers is the panacea. Oh, yeah, there's one of your little fun words there that the stupid academics like to use a lot for all privacy concerns. However, in the Cloud Memo, we explain that EU entities can be within the reach of the Cloud Act, even if the EU entities are located outside the U.S. Since the U.S. Cloud Act became effective in March 2018, Microsoft has received more than 200,000 requests for customer data from governments around the world, including 4,000 or 45,000 requests from U.S. law enforcement authorities. These numbers include requests with secrecy orders, gag orders, and includes those successfully challenged by Microsoft. Microsoft did not specify any disclosures pertaining to EU-based enterprises. Further, the Microsoft definitions of customer content data and enterprise content data may include personal data of EU residents, but are not limited to it. And of course, none of that matters because they're all run through Amazon Web Services, even Microsoft, IBM, all the other corporate. Every single thing just about is run through Amazon Web Services. So of course, they can just instantly and without limitation share whatever data they have in that system with anybody at all. And they don't have to follow any of these red tape loopholes that apparently are set in place for our protection. Microsoft stated in November 2021 that they never provided access to any personal data of public sector organizations in the EU to any governmental authority, of course, because it was all done through Amazon, right? Through Amazon Gov Cloud Services. Since July 2020, Amazon has consistently stated that they have not disclosed any enterprise or government content data to U.S. law enforcement stored outside the U.S. And again, like I said, that's just a narrow parameters excuse where if they didn't do it within that narrowly defined explanation. Simplified, this comes down to a setup where personal data is encrypted at rest, transferred securely to a cloud provider, then pseudonymized meaning the names are made fake or something like that, within a trusted execution environment. This results in a pseudonymized data set that can be used freely. The additional information required for relinkability is only accessible to the data controller. This is a solution that elegantly puts in practice the first three use cases: 1, encryption at rest; 2, pseudonymization; and 3, encryption in transit of the EDPB, recommendations on measures that supplement transfer tools to ensure compliance with the EU level of protection of personal data. And that protection of personal data is specifically and only for them and their control mechanisms, and does not actually have to do with the general population, as it were, because they could really not give a crap, because they are all about control by any means necessary for their own benefit, and that's period. So this next document is Cloud Gavel, Electronic Warrants Proposal for Bastrop County, Texas, June 14th, 2024. Cloud Gavel is pleased to submit the proposal for services to support the agencies within Bastrop County with our cloud-based electronic warrants solution. Cloud Gavel brings speed and efficiency to the warrant process. The Cloud Gavel solution is all-inclusive and delivers these impressive features. Any internet-capable device can prepare and submit warrants to the judge from anywhere at any time. Solution supports unlimited users in your agency, simple to set up, administer, and use. No hardware or software to install or support. Pricing is population-based, so the cost scales from smaller to larger agencies. A single agency can participate along with their judges, and or all agencies in a judicial district or county can participate together as a multi-jurisdictional solution. Regional solutions can easily grow out over time. Tailored for your state and agency. Cloud Gavel, at no cost to your agency, sets up your unique state forms, arrest subpoena, and your statutes. So they write the law too. As well as your judges, districts, and other location-specific data to speed data entry and warrant creation. Well, I should say they write their laws. None of these laws have ever been legitimate. So-called laws, anyway. Custom integrations where desired. APIs allow integration of Cloud Gavel with agency RMS systems, eliminating duplicate data in many cases and enabling effective information sharing. Enhanced security. CGIS compliant hosting environment with high security protocols hosted on Amazon's government AWS cloud hosting environment. The best quality in the world. If required, a secure video conferencing link between the officer and judge can be utilized. A judge is able to review the warrant and respond from anywhere, eliminating the need to be physically in any office. Wow. And of course you could have all those things pre-recorded, you know, and slightly changed with quote-unquote AI. We are providing an unlimited use license for the law enforcement agencies, detective units, courts, and district attorney users. That's your big one, right? Attorneys, of course. And these attorneys, as we know, are behind most of this stupid garbage, illegitimate, fraudulent, criminal, treasonous coup that they're attempting to implement against the military apparatus. Users for our Cloud Gavel e-warrants and e-service solutions. Cost listed above is a collective cost for the entire county. The county can divide the amount cost amongst all participating agencies within the county, whereby each agency would be invoiced for their agreed portion. The listed cost does not include any integrations with any third-party solutions. This cost will need to be negotiated in conjunction with those vendors. Now, it's signed with no date, and that doesn't look like a real signature at all. Casey D. Roussel, President CCO. This next document is to Julia Finn, Legislative Analyst, from Barry Lucier, IT Project Manager, an act to establish a statewide electronic warrant system. This is just the cover story, right? As we've seen with most of these documents, whenever something's passed through the legislative branches, the actual legislators or representatives are simply figureheads to produce public theater. They're like actors and actresses. The actual operational meat and potatoes, so to speak, of this is just done through departmental paperwork, and that's it. Somebody makes the paperwork, signs off, and sends it through, and then it's verified through the different offices, and they process it. And that's all that happens. The only reason why senators or House of Representatives or any of those people ever sit to decide on anything, because they never decide on anything, is just to play face to the public. This memorandum is to help the administrative office of the court to prepare a reliable and accurate response to the legislature's request. That's going to be another document, of course, for more information about the potential costs and savings associated with implementing a statewide electronic warrant system, hereinafter referred to as the e-warrant system. Of course, they're going to do it regardless. This is simply sort of like an employee's workup of how it will be done, so to speak. This bill directs the state court administrator to establish a secure system, and it's going to be written by an attorney, of course, for the application, issuance, and return of arrest warrants and search warrants that is electronic, that provides access to authorized users statewide. This bill amends the law on search warrants to require electronic application and issuance once the electronic system has been established. The bill directs the Supreme Judicial Court to adopt amendments to the Maine, this is Maine specifically, Rules of Unified Criminal Procedure Rule for arrest warrants of summons effective on the date of the establishment of the statewide electronic warrant system to provide for the application, issuance, and return of arrest warrants and search warrants through electronic means. This lists something called Tyler Technologies, whereas the other one we read was Cloud Gavel. Critical assumptions. All probable cause arrest and search warrants to be performed in the e-warrant system. The system would replace any and all paper processes. Justices of the peace, the JOPs, with the necessary... So JOP means Justice of the Peace. The estimates below contemplate both the inclusion and exclusion of JOPs in the e-warrant process. The e-warrant system, as proposed, would be implemented as a standalone system with the potential for an interface to exchange basic data with the judicial branch's Odyssey case management system. The e-warrant system does not need to interface with the state police Metro switch. Arrest warrants would continue to use the manual process in place for entry on and removal from the switch. That's, of course, going to be a transitional measure that has to do with operational components, as in the people currently operating it have been trained and used to function on this one system, and simply transitioning to them to another one abruptly will cause a problem, and so they need to make that a gradual transition, as they always do that. And mind you, this document is from 2021. So this has definitely already been implemented for a couple years now. Important, this analysis assumes that all Maine state police users and only some local agencies will be equipped with the necessary hardware and network connectivity. All other local and county law enforcement agencies will need to purchase, deploy, and install hardware. Each user agency will identify one or two users that will be assigned to the system administrator role to manage users for the agency. One or two users will be assigned to the system administrator. I bet we know what type of individuals those one or two users will be. And I expect very probably attorneys, possibly operating behind cover identity, so that's hard to say. If this assumption is correct, and the MJB as the system owner is responsible for user management and system support, then it should be expected that OIT would need at least an additional part-time business analyst position. And now I'm going to run to page 6 because the rest of this is not necessary. Tyler's e-warrant system is a SaaS product hosted in the AWS government cloud. Again, AWS is Amazon Web Services. None of the hardware estimates account for remote VPN access. Typically, this is needed to access the secure state of Maine network and its systems, but the Tyler e-warrant product is hosted on the secure AWS Amazon Web Services government cloud, so VPN access would not be needed. The legislature, as a cover entity, of course, has not for money laundering, has not provided funds for local agencies to purchase hardware or software. The funding source for those agencies is usually the local municipalities, county government, or grant funds. I would say pretty much predominantly they will be, quote, grant funds. Figures provided for law enforcement expenses are estimates only, although an attempt was made to have the Maine Chiefs of Police Association and Maine Sheriff's Association provide reliable numbers of their agency's user counts. those groups would not be able to provide them in time for this memo. So that's, of course, more examples of the entity laundering, the separation of things. So you can have an attorney through the Maine Sheriff's Association access and control this system at a long length distance. So in order to verify the identity of the individual, you have to jump through multiple layers. The MJB and the Maine State Police are currently both engaged in the Odyssey project. This project is a major priority and will likely not be completed until the end of 2022. At this time, it is estimated that implementing an e-warrant system would be approximately a 10-month project. So like I said, it's already been done. There is no discussion, there is no voting, there is no, quote, constitutional process. They just do it. Ohio e-warrant program letter of participation to Ohio Department of Public Safety. On May 31st, 2020, Warrant Task Force issued its report with recommendations. Innovate Ohio, the Ohio Department of Administrative Services, and the Ohio Department of Public Safety, so this is Ohio now, ODPS, have joined efforts to create the Ohio e-warrant protection order program, which consists of a web-based application e-warrant that will be provided to participating agencies at no cost. And I think we all know where that, quote, e-warrant system is being based out of. Allow stakeholders to track open warrants and protection orders and assist with the reduction of Ohio warrants backlogs. Entry of all warrants and protection orders into the federal NCIC system via leads by automating the process and eliminating duplicate entries in disparate systems. The system will provide real-time access to the status of warrants and protection orders, which will improve the thoroughness, accuracy, and timeliness of warrant and protection order submissions to leads for officer safety, public safety, and NICS firearm transfer decisions. That's a big deal right there, the so-called firearms transfer decisions. That is obviously an infringement on the Second Amendment, and with all of these documents, it's very clear that that infringement, as everybody just about has been saying for so long, is designed for an enemy operational control and takeover of the country itself by reducing the individual people's capability to defend themselves. Stakeholder training and deployment coordination. This participation will involve a demonstrated approach and commitment to working together with local stakeholders to design a system that will work for all entities engaged in these processes. I think we all know what that means. And this particular document has no signatures on it, but I guarantee the signed document's out there somewhere. Now this gets into the possibly even the more... When you link all these documents together to this one right here, stuff becomes very, very interesting. Automated License Plate Readers, or ALPR. This is a, quote, general order. Now, general order is something issued in the military for a specific purpose. You have a mission order, you have a warning order, and you have general orders. October 7th, 2024. I might have missed an order category there, but it doesn't matter. Anyway, they're using a military term here, general order, from October 7th, 2024. Assistant Chief Nicole Waldner. Since when can an assistant chief make some type of declaration like this? Now, interestingly, it has listed here a WILEAG, or W-I-L-E-A-G. At first, I looked at that and thought maybe that means mileage, but it's got to be something else. Amends General Order from July 2nd, 2015, 2015-34. Standard operating procedure, operation and use of automated license plate readers. Definitions. Automated license plate reader, a system consisting of one or more cameras and related equipment that automatically and without direct human control locates, focuses on, and photographs license plates and vehicles that come into range of the device. The system has the ability to capture quality images in a variety of settings, including darkness, oncoming headlights, bright sunlight, very low sunlight, deep shadows, and glare. Automatically converts digital photographic images of scanned license plates into electronic text documents utilizing optical character recognition OCR technology. Is capable of comparing scanned license plates text data with data files for vehicles on a BOLO list programmed into the device's electronic memory. Notifies police members by an audible and visual alert when a scanned license plate matches a license plate on the program BOLO list. So obviously this is equally the grid and Skynet. The term ALPR includes both devices that are placed at a stationary location, whether permanently mounted or portable devices, positioned at a stationary location, and mobile devices affixed to a police vehicle and capable of operating while the vehicle is in motion. Authorized user, civilian member of the department. Now here's something that's important to note. Police are civilians. However, when they say a civilian member of the department, I guarantee they're talking about, once again, attorneys. It's all attorneys. Always is. BOLO, be on the lookout, or BOLO situation. The determination by a law enforcement agency that there is an articulable and specific law enforcement reason to identify or locate a particular vehicle, or in the case of a post-scan BOLO, there is an articulable and specific reason to ascertain the past locations of a particular vehicle. BOLO list, also known as a hot list, is a compilation of one or more license plates or partial license plates of a vehicle or vehicles for which a BOLO situation exists that is programmed into an ALPR so that the device will alert if it captures the image of a license plate that matches the license plate included on the BOLO list. The term also includes a compilation of one or more license plates or partial license plates that is compared against stored license plate data that had previously been scanned in a collection by an ALPR, including scanned license plate data that is stored in a separate data storage device or system. So it's possible to say that you might not be able to get away with against this evil system and treasonous system by simply changing a couple of the digits and numbers on a license plate. But you could probably put a fake license plate or temporary tags that you mocked up and scanned through the system as a way to kind of dodge these things. But then again, they might register through the data and say that's not a real license plate, so on and so forth. Criminal event. Now this is a pretext cover type, criminal event. But there are, as usual, a wide range of criminal labels, and they mostly will use that however they would like, just because it's the sanctity of law enforcement garbage. If they declare it to be criminal, it's criminal and no questions asked. A specific incident or series of related specific incidents that would not constitute a crime under the laws of the state of Wisconsin, or that would constitute a crime under the laws of the state of Wisconsin, whether or not the incidents have occurred or will occur within the state of Wisconsin. Now there's your wording there. Will occur. The term includes an attempt or conspiracy to commit a crime, such as conducting a surveillance of the location to identify and evade or thwart security measures, such as this garbage, of course. The analytical process by which stored ALPR data is used, whether alone or in conjunction with other sources of information, to detect crime patterns by studying and linking common elements of recurring crimes, to predict when and where future crimes may occur, and to link specific vehicles to potential criminal or terrorist activity. The term includes an automated process in which a computer program analyzes stored data to identify potentially suspicious activity or other anomalies involving one or more scanned vehicles, and where such automated analysis is done without disclosing personal identifying information about any individual to an authorized user or any other person except as may be authorized pursuant to blah 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 of this directive. So this directive determines whether or not you can access PII, and of course we'll find out that it is in fact very easy, and that section right there is meaningless. Information that alone or in conjunction with other information identifies an individual, including but not limited to such individual's name, date of birth, address, phone number, social security number, vehicle operator's license or ID numbers, financial accounts, or biometric records. Financial accounts. This term includes personal identifying information that is included within the data comprising a BOLO list, as well as personal identifying information that is learned by checking the license plate scanned by an ALPR against the Wisconsin Department of Transportation database or any other data system that contains personal identifying information. Any other data system. All information captured by an ALPR and stored in the device's memory or in a separate data storage device or system. This term includes the recorded image of a scanned license plate and optical character recognition data, a contextual photo, e.g. a photo of the scanned vehicle and or occupants, global positioning system GPS data when the ALPR is equipped with a GPS receiver or other location information, and the date and time of the scan. The term applies to both alert data and non-alert data that has been captured and stored by an ALPR or any separate data storage device or system. Non-encounter alert. Without revealing to the occupants of that vehicle that the location has been detected, relevant to a terrorist organization file VTOF alert. Now, of course, they can list absolutely anybody as a terrorist because they're widely defined element of terrorist is anybody, of course, who challenges the sanctity of law enforcement or the quote-unquote authority of the state. Meaning, of course, anybody that even breathes the word Constitution. ALPR and the data that are collected by these devices stored for future use shall only be used in accordance with the manufacturer's use manual and this directive. So obviously not the U.S. Constitution. To permit, which of course they can't adhere to the U.S. Constitution because this type of thing is directly prohibited by the U.S. Constitution. By the way, the document to which all uniformed members of the armed forces swear allegiance. That's important. To permit a thorough analysis of stored ALPR data to detect crime and protect the homeland. Now here's where we get into what we're talking about. Department of Homeland Security is a subset entity operating on behalf of attorneys from the United Nations, those who speak native Luxembourgish, Belgian, German, French, whatever, from that particular area, the United Nations. Coming here under the Department of Defense, or Department of Homeland Security, a moniker to transition all Department of Defense, quote-unquote, resources through their general counsel or partner attorneys to so-called law enforcement to establish their global law enforcement occupation army. And here we find out that, of course, naturally they're behind this too, because they specifically state to permit a thorough analysis of stored ALPR data to detect crime and protect the homeland. Department of Homeland Security. From terrorist attack while safeguarding the personal privacy rights of motorists by ensuring that the analysis of stored ALPR data is not used as a means to disclose personal identifying information about an individual unless there is an articulable, meaning written, and documented, also meaning written, law enforcement reason for disclosing such personal information to a law enforcement officer or civilian crime analyst. And there's your operative word there, civilian crime analyst. First of all, so-called law enforcement officers, as of yet, are not fully military. They are still civilians. Once they remove and decimate, as they plan, all veterans, uniformed military officer or enlisted, anybody who has taken an oath of allegiance to the Constitution, once they wipe them out, including myself, of course, then they will be the only quote-unquote military presence. Of course, they'll continue to call themselves law enforcement across the planet, and thus they will no longer be civilian. ALPR shall be used in a consistent manner to assist department members in accomplishing its mission in Homeland Security. Like I said, same people. The program administrator shall ensure compliance with this directive. That I know who that program administrator is. Members must ensure that the camera lenses are free from obstructions before operation. Members may remove obstructions such as snow, mud, paper, etc., but under no circumstances are the camera lenses to be wiped with anything other than glass cleaner or mild soap and water and clean, soft, non-abrasive cloth. ALPR-equipped vehicles shall not be washed in automated car washes. ALPR-equipped vehicles must be hand-washed. Additionally, the use of harsh chemicals and or brushes must be avoided. Not following this guidance will void the camera system warranty. ALPR-equipped vehicles should avoid becoming involved in vehicle pursuits whenever possible. Notify the dispenser that they are in an ALPR-equipped vehicle and request a marked police vehicle to take over the pursuit as soon as practical. So, for all intents and purposes, these vehicles are unmarked, meaning designed to look like everybody else's vehicle. That's interesting. Program administrators shall maintain a written or electronic record that documents the following information: the identity of all authorized operators, whether any ALPR data was transferred to any other database or data storage device or system. The IT administrator shall maintain a written or electronic record that documents whether any ALPR data was transferred to any other database or data storage device or system. The department's ALPR data record keeping system, which may be automated, shall document the following information: date and time of access, the case of access to stored non-alert data, the type of access authorized, or etc. Whether an automated software program was used to analyze stored data, and any other information required to be documented. Examples of articulable and specific reasons include, but are not limited to, Vehicles that are registered to or reasonably believed to be operated by persons who do not have a valid operator's license or who are on the revoked or suspended list. Wow, that's a priority. Vehicles with expired registration or other registration violations. This is ridiculous. This is a lot of effort to go through to ensure well, they have to, of course, ensure their control mechanism over the motorways, unconstitutionally, of course, or unlawfully, because the U.S. Constitution is the supreme law of the land, as it says, and they're just doing whatever they want against it, waging war, levying war, as it says. Persons who are subject to a restraining order or curfew issued by a court, or who are subject to any duly issued order restricting their movements. Any other duly issued order. And like I said before, this can be done at any time, any place, from anywhere by anyone who has access to the system. Persons who are on any watch list issued by city, state, or federal agency responsible for Homeland Security. That's your big one right there. I guarantee the majority of U.S. citizens are on watch lists. And most definitely, any actual military personnel member, veteran, uniformed, active, reserve, otherwise, it doesn't matter. I guarantee we are all on these watch lists. BOLO list information may be downloaded in batch from other databases, including but not limited to the National Crime Information Center, National Insurance Crime Bureau, United States Department of Homeland Security, of course, and the Wisconsin Department of Transportation database. Of course, this is, the so-called DHS, meaning attorneys acting under that cover story who are doing this. Police do not have reasonable suspicion to justify a stop based on a computer check that shows the operator's license of the registered owner of the vehicle is suspended unless the driver generally matches the owner's physical description. I love that word there, generally matches. In the event of a non-encounter alert, the police member shall follow any instructions included in the alert for notifying the law enforcement or Homeland Security agency. I bet they've been listing a lot of this stuff right now that had put out the BOLO. Authorized users may access and use stored ALPR alert data as part of the criminal investigation process, warrant service, or other anti-crime tactics. An authorized user does not need to obtain approval from designated supervisor for each occasion on which he or she accesses and uses stored ALPR data. An authorized user does not need to obtain approval from the designated supervisor for each occasion on which he or she accesses and uses stored non-alert data pursuant to this directive. Like I said, it's very easy. They can just do it at a whim. An authorized user may access and use stored non-alert data for purposes of conducting crime trend analysis. Well, there's your cover story there. I'm conducting crime trend analysis, whatever the hell that means. When such access and analysis are approved by a designated supervisor and where such analyses are undertaken to produce analytical products that are intended to assist the agency in the performance of its duties. It's very vague, and of course is going to mean that some foreign actor is going to have special access and control. A designated supervisor may authorize one or more authorized users to conduct a method or methods of crime trend analysis on a repeated or continuous basis, in which event such authorization may remain in force and effect unless and until modified or rescinded by the supervisor. Designated supervisor may also approve the use of an automated software program to analyze stored data to look for potentially suspicious activity or other anomalies that might be consistent with criminal or terrorist activity. I bet a lot of that is going on. Of course, by foreign United Nations attorneys, waging war on the country and the people. Nothing in this section shall be construed to prohibit. This passage is almost humorous if it wasn't sadly true. Nothing in this section shall be construed to prohibit a computer program from accessing and comparing personal identifying information of one or more individuals who are associated with a scanned vehicle as part of the process of analyzing stored non-alert data, provided that such personal identifying information is not disclosed to a person unless the specific and articulable facts that the warrant further investigation standard is satisfied. The specific and articulable facts that warrant further investigation standard applies only to the crime trend analysis of non-alert data, and nothing in this section shall be construed to limit disclosure of personal identifying information of a person who is a registered owner of a vehicle that is on an initial or post-scan BOLO list. This stuff's quite ridiculous. Stored ALPR data may be combined with ALPR data collected by 2 or more law enforcement agencies in accordance with this directive. Each agency contributing data to the combined database shall maintain a record of the data transfer, which may be an automated record, and shall have and keep on file a memorandum of understanding or agreement or other memorialization of the arrangement for maintaining a populated database comprised of stored ALPR data collected by multiple law enforcement agencies. And I've done a lot of videos on those already. Now, this is allegedly signed by Jeffrey B. Norman, but it was reviewed and approved by an Assistant Chief Nicole Waldner. So there you go. I believe that puts perfectly the picture of the practical and operational situation that we're looking at today, which unfortunately makes the Terminator, the Matrix, and many of these other movies, Tron, true.